What? That is the most Chewbacca defense crap I've ever read. Us, the defense attorneys, are going to speculate what our client might have been going through. Just ask your client!
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Announcing the latest episode of the Lawful Masses podcast. This one titled, They Tried to Put Ilsa in a Cage for the Rest of Her Life. Get access now by supporting on Sponsus, Patreon, or Twitch. So last week we went to Leibowitz's hearing where if he messed up bad enough, they were going to throw him in jail. And they didn't throw him in jail. But one of the things the judge discussed was a letter from Leibowitz's attorneys, and we didn't get to see the letter until the judge was going to put it on the docket, and they didn't want it on the docket until it was redacted. And they were going to give them 1 day to redact it. So then this is the now redacted letter from Leibowitz's attorneys. And they write on behalf of Richard Liebowitz, they say, in a contempt proceeding arising out of the above entitled copyright infringement lawsuit, which is Berger v. Imagina Consulting, the underlying action has since been settled and dismissed. And remember that they're writing this before. This was filed, or this was sent to the judge before the hearing. So this was their attempt to sway the judge in a totally legally sound way, but this was the best that they could do to sway the judge that Richard Liebowitz should not be thrown in jail. In Your Honor's order and order to show cause, dated November 1st, 2019, I'm guessing there were two separate entries, the court directed Mr. Liebowitz to appear in person before the court November 13th, last Wednesday, and as a penalty for Richard's continuing failure to provide the requested documentation of his grandfather's death, which was central to Richard's failure to appear at a scheduled conference on April 12th, 2019, run-on sentence of the year, Richard was ordered to pay a financial penalty to the clerk of court each Monday, amounting to $100 per business day beginning October 7th, subsequently raised to $500 per business day beginning November 6th, now totaling, by counsel's calculation, $3,700, not including the Veterans Day national holiday on Monday, November 11th. By the time Richard will appear before the court on November 13th, I have been assured that the entire financial penalty imposed by the court will have been paid. So he's setting the stage for Richard's compliance with the court's order. For the reasons set forth below, I respectfully request that the court vacate its two contempt orders, declare Richard's financial penalties satisfied, and permit him to continue to practice before this court. Counsel has advised Richard on the kind of substantial steps he can take to ensure that his poor judgment or lapse in the Berger matter will not be repeated. A. Richard's background. Richard is an unmarried 31-year-old who resides with his parents in Hewlett, New York. He graduated with a Bachelor of the Arts degree in Communications from the University of Pennsylvania in 2010, and with a JD degree from Hofstra University Law School in 2014. He was admitted 2015 by the Second Department of the Bar of the State of New York, and in the same year opened the Liebowitz Law Firm, located in Valley Stream, New York, where he has practiced continuously ever since. He has had no other employment, experience, or supervision as a lawyer. As an avid photographer, Richard's law practice has been devoted exclusively to protecting and enforcing the copyrights of freelance photographers under the federal copyright statute. Since its opening, Richard's law practice has grown exponentially, filing approximately 2,000 lawsuits under the federal copyright statute in the 4 years of his firm's existence. Moreover, because of his burgeoning practice, Richard's firm has grown commensurately. He now employs a staff of 12, 2 of whom are lawyers, including an associate with large commercial firm experience. In short, while Richard is short on legal experience and training, he obviously fills a need in the ranks of freelance photographers who struggle to make ends meet financially, while their work is often often used by commercial entities, mostly media companies, without permission or compensation. And despite the volume of his practice, his clients have never filed a grievance against Richard or complained about the representation they received from Richard or his law firm. They attached some kind of letter from Bruce Kotler, the president of the New York Press Photographers Association, the largest and oldest association of photographers in the country, reflecting some kind of contribution and service that Richard and his firm has provided to the working photographers of New York City and elsewhere. We'll look at that if that's attached here. In counsel's view, however, this matter is not about the peculiar nature of Richard's law practice. It is about Richard's failure to carry out his responsibilities to the court and adversary counsel, a lapse caused by the death of a beloved family member, producing in Richard a brief period of overwhelming grief and dysfunction. Starting to lay it on thick here, guys. Attached to this letter as Exhibit C is the original death certificate confirming Jamie's death on April 9th, together with a receipt from the funeral home given to the Liebowitz family for their payment of expenses for the preparation of the body in the Fairview, New Jersey cemetery on April 9th. I think I have relatives in that same cemetery. The funeral home's receipt is attached to this letter as Exhibit D. On Friday, November 8th, 2019, I spoke by telephone with Malky, an employee of the funeral home, who confirmed to me that the funeral home had received, prepared, and buried the body on April 9th, a representation corroborated by the death certificate. Moreover, the identity of Jamie as Richard's grandfather is confirmed by the birth certificate attached and some other ancestry information, because they're trying to reassure the judge that they haven't substituted some other dead person. Okay, great. So just in case you thought that he rose to that level of making up a dead person, they're trying to show you, no, he actually died. Okay. Richard's failure to appear or notify the court. The court scheduled a discovery conference in the underlying case for Friday, April 12, 2019. Richard did not attend the conference, nor did he send anyone from his firm to cover for him, and he failed to call the court to explain his absence. Richard first contacted the court on Monday, April 15th by letter, informing the court that he had a death in the family and apologized to the court and opposing counsel for not appearing. The court now knows from the foregoing discussion that Richard's initial explanation for his absence was true. His grandfather, with whom he had a close and loving relationship, had recently died. Richard's problem in this matter arose during the rescheduled telephone discovery conference on April 18th, during which, in response to the court's probing questions, Richard mistakenly identified April 12th. Mistakenly identified, because it was mistakenly, it wasn't intentionally, it was mistakenly identified April 12th, not April 9th, as the date his grandfather died, a mistake he continued to make several subsequent submissions to the court. A mistake he continued to make in several subsequent submissions to the court. Really. Mistake. I made a mistake, and then I doubled down on my mistake, and I knew my mistake was not the truth, but I continued to make the mistake over and over and over again.
He was just so overwhelmed with grief, it's understandable.
Yes, I made the mistake of lying. Certainly the court would have understood and excused Richard's absence, whether the death occurred 3 days before the conference or on the morning of the conference, particularly since the court appeared aware of and knowledgeable about Orthodox Jewish custom and tradition concerning the week of mourning after the death of a loved one. Now, the judge, I don't know if you remember, but the judge pointed out that Richard filed things under his own name and under his own signature and under his own ECF filing login 2 times during the week of mourning. But Liebowitz, he said to the court, or his attorney said to the court, that he has attorneys working for him who file those things. But I would point out that there are some jurisdictions in the country that have found a misuse of your ECF filing login to be a disciplinary violation and to require disciplinary action. If 3 lawyers at my firm have filing logins, then they have to file under their own login. If I'm the only one with the filing login, then I'm the one that does the filing. I don't give it to my secretary to do it. I do it. But I guess other attorneys can differ on that practice. If he was approving it, there's an argument that it's okay. If it's under his if it's still his responsibility, then maybe it's okay. So I don't want to like crucify him there, but the practice does have to be done properly or else it crosses the line. If another attorney is filing something that they've written but under your login, that's probably improper, especially if you haven't reviewed it and approved it. There can be no excuse for Richard's lapse, whether he stated and maintained the erroneous date of death mistakenly or intentionally. Either would be understandable. For example, Richard may genuinely have misremembered the date of death and continued to adhere to the April 12th date, or, having taken the position that the date of death was April 12th, he saw no reason to question his memory or why it should matter. On the other hand, Richard may have thought the court would not understand his dysfunctional grieving state originating 3 days before the conference and decided to fix the date of death as the morning of the conference. If the latter explanation is the correct one, Richard not only misjudged the court's knowledge, experience, and decency, no doubt as an inexperienced young lawyer might, but he engaged in inexcusable falsity, however immaterial. What? That is the most Chewbacca defense crap I've ever read. He's not responsible because he might have, because us, the defense attorneys, are going to speculate what our client might have been going through. Just ask your client. The defense attorney, yes, the defense attorney is mystified as to how his client could do any of this. Apparently, he has not asked his client. I get it that Richard doesn't have to provide a defense, but this is just mere speculation.
He may not have asked his client because he was worried that his client might tell the truth.
Yeah. Of course, either way, Richard has paid a high price for his failure of memory or falsity concerning the true date his grandfather died. I don't think that's it. I think it was the doubling down and tripling down and telling the court that they didn't have jurisdiction and refusing to provide answers to the court's very, very simple questions. I think that's what did it. The incident has been a financial disaster. Richard will have paid the court $3,700 in financial penalties for his alleged contempt. He has paid adversary counsel for his adversary's wasted time at the conference, which Richard failed to attend. And Richard has paid thousands of dollars in attorney's fees for counsel's representation in this contempt matter. Nor is financial loss the only adverse consequence. He has suffered horrible publicity as a result of being held in contempt and threatened with incarceration by this court. And of course, Richard, a young and inexperienced lawyer, is scared of the damage to his professional career as a result of his conduct with these proceedings. At the risk of appearing to minimize the seriousness of this matter, which counsel would not dare to do, counsel urges this court to find Richard has suffered or been penalized enough for his lapse or misconduct. There were secondary consequences, therefore they should take the place of the primary punishment. I don't know. Wasn't there that one case, the internet versus Rakowski versus the internet? Wasn't that it? Yeah. There was Rakowski versus the internet. There was a guy who got out of law school and pretty much went fresh into a capital murder trial as primary counsel. And I think botched it. And this happened. This happened. There were other people who talked about this case, this Rakowski case or whatever his name was. And those people all got sued by him, including his own law school. He sued his own law school. I believe the only parties that paid out were actually his own law school, which paid like $8,000 to him or something like that to go away. And then everybody else won against him, and we all laughed. And now I'm going to get sued again. No, I never got sued in the first place. One of my colleagues did. One of my mentors did. Jordan Rushy, I believe, got sued by him. Remedial efforts. Counsel was not retained until Thursday, November 7th for a Wednesday, November 13th matter. Insufficient time to propose to Richard a full range of actions designed to bolster the efficiency and professionalism of his practice. Counsel has, however, recommended that Richard seek psychotherapy to understand withstood and ameliorate the anxieties, tensions, and infrequent lapses of Richard's demanding practice. And I believe that there is a section that's redacted here where they identify that he has, in fact, sought counseling. Richard has also recommended, or counsel has recommended, that Richard enroll in a CLE course addressing small law firm management. Sure, those are good. Moreover, since counsel is not particularly familiar with the law of intellectual property, specifically copyright infringement and enforcement, counsel does and will recommend that Richard seek out a respected mentor in that field whom counsel has yet to identify. Finally, counsel has known Richard and his family for years, even as long ago as Richard's bar mitzvah, and will always be available to render advice and guidance to Richard, and counsel will advise Richard to make use of this resource more often. Counsel thanks the court for its patience, understanding, consideration. Richard has learned an important lesson. Counsel doubts that the court will hear about any serious lapses again on the part of Richard Liebowitz. So yeah, hopefully not, but this should never have gotten this far. Now, that, I think, in my opinion, that is a remarkable piece of basically emptiness. Like, what can you say? You can't say, yeah, my client lied to the court, but he's real sorry that he got caught. So you have to come up with something. Like, what can you write other than, he didn't mean to do it and we're sorry? And that's about it. And like, try not to make it worse. That's really all you can do sometimes, is try not to make it worse. The fact that he brought attorneys with him and put on at least a show of a defense at least means something to the court, but it didn't mean much to this particular judge. She let him get away with paying the $3,700 when the number was really $3,800. But she is referring him for disciplinary action, and he didn't have to go to jail. Why didn't he have to go to jail? Let's be clear about this. He didn't have to go to jail, not because jail isn't a proper punishment for disobeying a court order and lying to the court and all that. It's because now is not the proper time. We are here, or we were there, on criminal contempt of court, which is meant to compel something, not punish something, meant to compel some kind of compliance. It could literally be that someone is being disrespectful to the court, so it could be very much punishing someone for disrespecting the court, but the punishment is to compel the compliance. Well, here we have the death certificate and everything, and all the supporting documentation and all that. So is there anything more to compel? Is he in further violation of a court order? No. He's certainly guilty of lying to the court and can suffer further disciplinary action after a proper investigation and hearing by a disciplinary authority that has jurisdiction over him, like the courthouse grievance committee, like Judge Sibel said. So he will be getting some kind of punishment or grievance or reprimand or suspension or something. It's just not now. Now is not the time to throw him in jail. He was only going to get thrown in jail if he was in further disobedience of the court's orders. So what do we think of that? That's the current conclusion to the Liebowitz saga with that part of the saga. So now we get to wait for when the disciplinary complaint comes. We probably won't see it until an actual disciplinary action is taken, like a reprimand or something like that. Then we will be back with the next Liebowitz story. Until then, I hope he keeps his nose clean. I hope he serves his clients well. And I hope that he has nothing but good things to report by the time the disciplinary complaint comes rolling around. That'll look good for him. So if I don't ever hear about Richard Liebowitz again in a negative way, I'll be very happy about that.
I mean, honestly, this document is just a bunch of pseudo-ass kissing, right? Like, it's not really kissing the judge's ass, just like sort of pretending to, you know? Yeah. And I doubt we won't hear about Liebowitz doing something crazy again in the next few months. Like, it seems unlikely that he's just going to stop now. Not after, like, what kind of stuff do you think they haven't caught that's active in ongoing cases?
You mean like there might be some other loose ends? Yeah, there might be some other sanctions that are coming down the pipeline too for some other behavior. So yeah, we'll present all of that if we find it, because this has been a remarkable case of a rising star that maybe rose a little too fast. Maybe Icarus flew a little too close to the sun, huh?
He'd be smart to stop until he does the CLEs and finishes some psychotherapy, I would imagine, too. If he continues, if something else happens after this fact, and he hasn't done the CLE training in the meantime, that's going to look really bad.
All right. Well, that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney, and this is your favorite legal news show, Lawful Masses with Leonard French. Thank you to our supporters on patreon.com/ljfrench and sponsors.com/law. We would not be here without your financial support, including the financial support of our November $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters who will be scrolling in front of me on the crawl in the outro of the videos and on the LED panel behind me back there. Everyone now has access to the supporter-only Lawful Masses podcast. If you are a $1 supporter or a Twitch subscriber, or we're going to figure out how to do the YouTube membership thing here, then you get access to the podcast. This latest episode is about how the state of Pennsylvania wanted to put my dog in a cage for the rest of her life, and how we went about handling that court case and all of the emotions and all that went along with it. It's a very dramatic story. I think you'll really enjoy it. So thank you for watching. Thank you for donating. Thank you for your support. Thank you for your love. We love you too. I am Leonard French, your favorite copyright attorney, and I'll see you in the videos that drop. Bye.